pleasant day to everyone. I am Faith Kabatbat and I am here to present to you the case of Reyes versus the Secretary of Justice with the GR number 120817 dated November 4, 1996. For the petitioner is Elsa B. Reyes and Court of Appeals Secretary of Justice, AFP Mutual Benefit Association, Inc., and Graciela Elizar for the respondents. So here's the case outline. First is the background of the case, next is the facts, and then the issues, and lastly the held. Here's a quick background of the case. Elsa Reyes is the president of Eurotrust Capital Corporation, a credit finance company based in the United States, and Graciela Elizar is the president of BERMIC, also known as B.E. Ritz Mansion International Corporation, a domestic real estate development company. Then, Armed Forces of the Philippines Mutual Benefit Association Incorporated, also known as AFP-MBAI, is the other respondent. It is a company properly constituted principally to provide welfare services to the Armed Forces of the Philippines. The petitioner claims that Eurotrust and BERMIC reportedly agreed to a financial agreement to finance the construction of her business. Eliezer failed to make good on dishonored checks, thus the petitioner filed for BP-22 and estafa. Reyes also alleges that she cannot be held criminally liable for the alleged conduct since the contract of sale of securities between her and AFP-MBAI was novated by debtor replacement. She claims that, rather than fulfilling her duties under the loan contract to repay the petitioner, Eliezer accepted petitioner's obligation under the sale of contract to pay AFP-MBAI directly. Reyes petitioned the Secretary of Justice for a reconsideration of the above-mentioned resolution, claiming that novation had not occurred. The sums paid by AFP-MBAI to Eurotrust for those securities were then loaned to BERMIC by Reyes, according to the respondent, AFP-MBAI. After realizing that the money originally handed to BERMIC by Eurotrust belonged to AFP-MBAI, Eliezer demanded a meeting with Eurotrust. As a result, BERMIC opted to settle its obligations directly with the fund's true owners. Despite their agreement, the petitioner proceeded to collect on the PDCs according to Eliezer. BERMIC wrote to Eurotrust as a consequence, demanding that the funds be kept in constructive trust for the rightful owners. Reyes, on the other hand, kept assembling. On the advice of her lawyer, the respondent Eliezer had the payment suspended. As a result, her Eurotrust-related checks were returned unpaid. Elsa Reyes' claims against Graciela Eliezer were dismissed by the Office of the Provincial Prosecutor of Rizal on the grounds that when the latter accepted Reyes' commitment to AFP-MBAI, it constituted novation, eliminating any criminal responsibility on Eliezer's part. Moreover, the petition was dismissed by the Secretary of Justice, who maintained that the novation of the loan prevents the rise of any incipient criminal liability because the novation had the effect of canceling the checks and rendering the subsequent dishonor of the already cancelled checks without effect.
The issue of this case is whether or not that when they decided that respondent Eleazar should settle her firm's loan obligations directly with AFP, MBAI, and DECS IMC instead of petitioner Reyes, the loan contract between petitioner and respondent Eleazar was novated.
The disposition of the case. There was no novation in this case at the bar. Accordingly, finding no reversible error in the decision appealed from dated May 12, 1995, the same is hereby affirmed in all respects.
The dictum: to be sure the following requirements must all be met in order for innovation to take place. First, there must be a previous legitimate obligation. Second, the parties must agree to a new contract. Third, the old contract must be terminated. And fourth, the new contract must be valid. The remaining three necessary requisites of novation are missing in the current instance, based on the circumstances disclosed in the new record. There has been no new agreement for the substitution of creditor war created among the parties involved to replace the previous contract. Novation, which consists in substituting a new debtor in lieu of the old one, may be accomplished even without or against the latter's option but not without the permission of the creditor, says Article 1293 of the Civil Code. The new debtor receives the rights specified in Articles 1236 and 1237 as a result of his payment. To be valid, a creditor's approval to innovation by change of debtor is just as important as the creditor's consent to innovation via traditional subrogation. The fact that AFP-MBAI receives payments from respondent Eleazar, who agreed to take petitioner's obligation under the contract of sale of securities, does not prove novation at best. It simply establishes a legal relationship of co-debtorship or suretyship between respondent Eleazar and the petitioner's contractual duty to AFP MBAI, and the latter can still execute the obligation against the petitioner.
And that's it for the case of Reyes versus the Secretary of Justice with the GR number 120817 dated November 4, 1996. That's all. Thank you.